a conclusion that an offender is a danger to the community. All I am saying is that the facts of this offense and the other facts found by the trial court do not support a conclusion that Mr. Fuller is likely to commit sex offenses in the future. Now, the facts of an offense could, in some circumstances, demonstrate a likelihood of committing sex offenses again, but there has to be a nexus between the facts of the case and the future. And that nexus cannot be speculation or be based upon anecdotes. It has to be based upon evidence and authority. So I'd like to give you an example from the case law, the limited case law that we have. In Garrett, the state had argued that evidence of the defendant's untreated mental health issues indicated he was a danger to the community. Now, at first blush, that sounds somewhat reasonable. But the Court of Appeals pointed out in its holding, quote, defendant's mental health issues may show that he is a danger to the community if the state is able to show that those issues led defendant to have an increased risk of engaging in sex offenses after incarceration. However, the state offered no evidence showing that there was a connection between defendant's diagnosed mental health conditions and the commission of sex offenses or recidivism generally, end quote. The same goes here. The state offered no evidence or authority that the facts of this case indicated Mr. Fuller was likely to commit sex offenses in the future. There is no nexus. There is no connection.
With all due respect, that Garrett decision is an unpublished Court of Appeals opinion for context. Is that right?
Absolutely. Absolutely. It's just one of the only two opinions we have and that we've had for a decade on this issue.
And also, in terms of what I'm hearing about the findings of fact, you're not contesting the findings of fact because they were not raised for being challenged. You're only challenging whether or not the findings of fact support the conclusion of law that the defendant is a danger to the community. Is that right?
That's essentially correct, yes.
Thank you.
You know,
Mr. Testimony, I apologize. If I could, setting aside Garrett and Pell, if you look at the statute 14202, we're focused on whether or not the defendant is a danger to the community. Is that correct?
That's correct.
What is the definition of is in the statute?
Your Honor, I don't know if there's a definition of the word is.
Okay, but if it were a present tense word, would you agree that we do not look to the future?
That could be. Yeah.
And I'm sorry, go ahead.
Well, I mean, we're working with 10 years of precedent here, right? Like this isn't against the blank slate. You know, we have had Pell for 10 years. In that 10 years, and we have Pell and we have what Pell said danger to the community means, which is that the offender is likely to commit sex offenses in the future.
Right, I understand. But if Pell were incorrectly decided based on a wrong interpretation of the statute, then this court would have the ability to revisit that, wouldn't it?
Perhaps, except for the fact that that definition that has been in our case law for 10 years makes sense because the point of the registry is to protect the public. So it makes sense to put people on the registry if they pose a risk of committing sex offenses in the future. If they do not pose that kind of risk, it doesn't make sense and it doesn't protect the public and therefore further the registry to make them register. All that is an extreme intrusion upon privacy with no corresponding benefit to society at all.
Right, but you are contending, and correct me if I'm wrong, that we should look at predictive indicators as opposed to past or current behavior. Is that right?
Yes, although in some circumstances, present behavior could be indicative of future risk. It just depends.
Okay, and past behavior as well.
Yes.
Okay, thank you.
If anything, the facts of this offense actually indicate Mr. Fuller is not likely to commit sex offenses in the future. So for one example, we're all familiar with the static 99 risk assessment by this point. it has a category for victims who are strangers versus those who are not. An offender gets a point indicating a risk of recidivism for stranger victims, not for victims who are close friends. So the trial court's finding that Mr. Fuller took advantage of a close friend rather than a stranger actually supports that he is not likely to reoffend. Also, Mr. Fuller accepted full responsibility for his actions. And I cited authority in our brief supporting that acceptance of responsibility indicates someone is less likely to reoffend. Also, as Judge Brooke pointed out, Mr. Fuller had no mental health or substance abuse issues that would cause this behavior to occur again. He had no prior convictions of any kind, let alone of a sexual nature. The state did not have any risk assessment evidence or any expert testimony to show that Mr. Fuller was likely to commit sex offenses in the future. And on top of all that, Mr. Fuller was ordered to complete a mental health evaluation specific to sex offenders and comply with recommended treatment, which makes it even less likely that he will reoffend after he completes probation. So this really boils down to an argument by the state that he did it before so he could do it again. But you could say that for anyone who has ever been convicted of any crime without evidence and authority that specific conduct indicates a risk of recidivism. All you're left with speculation, which will lead to arbitrary rulings like the one we have here. I want to
let me jump in and ask you a question. Can you hear me okay?
Sure, yes.
Okay. As I understand the trial court and the Court of Appeals analysis of this case is they were troubled by the fact that this continued to go on over a period of a couple of months. And in fact, the Court of Appeals pointed to that he had downloaded more than 50 photographs. And I understood that to mean that the repetition that involved indicated the willingness to repeat the offense, which seemed like a risk to them. What's wrong with that analysis?
Well, let's make sure we're clear about it. First of all, the indictment alleged a time frame of June 18th through August 4th. So that's a month and a half. Okay, that's the outside realm of what we're dealing with. But Mr. Fuller pled guilty to one offense that occurred on one day. That's on the judgment. But also, this isn't a situation where Mr. Fuller committed offenses against multiple people in different places over a long period of time. You know, in Pell, the defendant pled guilty to peeping on his employees, on his neighbor, 8 times over the course of 4 years, and that was still not enough to show he was likely to commit sex offenses in the future without any other nexus. So perhaps some sort of pattern of behavior, if it occurred over a longer period of time in different scenarios, maybe that could be predictive enough for a nexus, but this was not.
Well, the other thing that the trial court noted was that he moved the device around during that period of time, and that each time he did, he had to do an intentional act. Again, a sort of a reference to repetition that seemed to be troubling to the trial court.
Yeah, it's interesting.
That?
Sorry, go ahead.
Oh, am I misreading that?
No, I mean, you know, it's interesting that the state argues to the trial court the fact that he had 2 devices is more indicative of a risk for the future. And the judge then turns around and says, no, I actually find that having 1 device and having moved it is more indicative. So that's the problem with a lot of this, is that you could just as easily say the opposite for a lot of these factors. So say, and the sophisticated means, you know, you could say where a defendant does not use sophisticated means, it would be very easy for him to do the same non-sophisticated crime in the future. The problem when you don't have evidence and authority establishing that nexus, that connection to the future, is that it's subjective and it's speculative, and that produces arbitrary rulings.
Isn't that predictive behavior inherent in any of this in terms of the sex offender registration requirement? If it's in the discretion of the trial court, wouldn't all of that be a measure of predictiveness? Since, to use the cliche, nobody has a crystal ball in this.
Right. That's what the judge is doing. First of all, let me be clear. It's not the judge does not have discretion. This is a legal standard. Do you meet it or do you not? Danger to the community. The case law gives us what that means. That means risk of committing sex offenses in the future.
Well, I appreciate you bringing that up, actually, because I was going to ask you eventually. I'll ask it now. What's your reaction to the plea arrangement terms that the defendant agreed that the sex offender registration determination, if any, would be in the discretion of the sentencing judge, especially considering the fact that there was a discretion used in that respect that the defendant agreed to, and the fact that there was an exercise of that discretion that you say the trial court doesn't have?
Well, my reaction is I honestly do not know what Judge Tyson is talking about. Because that is nowhere in the plea agreement. Defense counsel agreed it should be determined by the court because defense counsel contested sex offender registration, right? Defense counsel is saying, we agree to plead guilty to this crime, but we don't agree that sex offender registration is appropriate. In fact, we want a hearing on that because we contest that. So, nowhere in that record is the word discretion. If you look at the plea arrangement, it should be determined by the trial court, it's not in the trial court's discretion. So that came out of nowhere.
So you did not construe that aspect of the terms of the plea agreement, that there should be a determination as to that by the trial court, that the trial court therefore was going to make a decision that the trial court would determine itself.
No, that's exactly what I think, but not that the trial court was going to make that decision in its own discretion. Not that it was a discretionary decision. Because it's not an automatic registrable offense, it has to be determined. Are they a danger to the community, and does it further the purpose of the registry? That's the only way you could get on the registry. So a judge has to make that determination.
Is there a meaningful difference between the plea arrangement saying that it shall be determined by the trial court as opposed to the term discretion being used?
Absolutely.
How would that difference be as we would look at it in reviewing the entirety of the record?
Well, saying that something should be determined by the trial court is merely saying that it's going to have to be decided after a hearing with evidence and then findings and conclusions by a judge because we don't agree, right? It would be the same for anything, SBM, any other type of proceeding that you would need to have where I'm not agreeing to that because it's not appropriate. So we have to have a hearing and the judge has to make a decision. That's all it was.
Do you interpret the language from Judge Tyson's separate opinion that you alluded to a second ago as saying in effect that such a provision in a plea agreement changes the standard of review on appeal?
I suppose it could. I would have a hard time. I mean, if somehow defense counsel had said, this should be a decision in the trial court's discretion, and then I get the case on appeal, first of all, I'd be like, what were you thinking? But I don't know. It might tie my hands.
Well, do you know of any instance in which the terms of the plea agreement can change the standard of review for a particular issue for purposes of appeal?
I do not. I think that's something that the appellate court has to determine on its own.
Do you have an opinion as to whether a counsel has the ability to do that?
Oh, counsel, please don't ever do that. I don't.
But that was what I got out of Judge Tyson's separate opinion was that in effect that by putting that language in the plea agreement that somehow the trial court was freed from the otherwise applicable legal rules. And that struck me as an interesting.
Two things about that. One, it's divorced from the facts. So if you actually look at the plea arrangement, you're not going to see that, right? All it is it should be determined by the trial court, right? So,
which would ordinarily mean we would then decide it on the basis that we would decide any other contested issue.
Yeah, yeah. The other thing is that the state did not petition for discretionary review based on anything that was in Judge Tyson's dissent. So none of that, and they didn't argue it in their brief. So none of that is before the court. This is a mixed question of fact and law, just like any other mixed question of fact and law. And another point of,
so if that, just to follow up just a second, if that's the case, then what we're supposed to do on appeal, as you understand it, is first of all look at the trial court's findings, ascertain whether they have sufficient evidentiary support, and then determine whether such of the findings that do have evidentiary support, disregarding any that don't, support a determination of whether the statutory standard is met.
that is correct.
Okay.
That is correct. And to the extent I challenge anything, it's just that we've continually argued that this was not a long period of time when you look at the case law, right? When you look at Pell. So to the extent that's a finding by the trial court, yeah, we've contested that all along, that this is not over a long period of time. And I think Justice Morgan was getting at something else that I wanted to address. In terms of discretion, we can't have a scheme where certain conduct indicates a risk of recidivism in one place in New Hanover County, while that same conduct does not indicate a risk of recidivism in Wake County. That goes against the fundamental principle that everyone should be treated equally under our law, no matter where you are in the state. So, that's why I said what I said in the reply brief about some of the arguments by the state. This can't be a situation where you look at the same findings and you could come to two different conclusions. That would be untenable for lawyers, for anyone to deal with. I do want to take a moment to stress what's really at stake here. 30 years of being branded as a sex offender on the internet, where anyone can view your picture, your address, your date of birth, your height, weight, eye color, hair color, sex, race, more. 30 years of being subjected to more than 20 felonies and misdemeanors if you fail to comply with any aspect of the registry. 30 years of not being able to live where you want to live. 30 years of not being able to go where you want to go or do the job that you want to do. The state now argues that being on the registry is far less onerous than being on SPM, but interestingly, the state made the opposite argument to this court in Grady. There they argued, quote, and this is from the Grady opinion, quote, SPM is not a significant intrusion beyond that associated with sex offender registration, end quote. We agree with that argument by the state. There are serious consequences to being on the registry. And because of those serious consequences, the state should have to meet a high burden to show that the offender is likely to commit sex offenses in the future. I did want to go back. Sorry, did somebody say something? I did want to go back to one other thing to follow up. Pell has been the law for 10 years. Pell said that danger to the community means a person is likely to commit sex offenses in the future. And Pell held that the state's showing in that case was insufficient. During that 10 years, we had Garrett also holding the state's evidence was insufficient. So those cases have been a guide for trial and appellate lawyers for a decade. And Mr. Fuller's counsel legitimately relied upon those two cases, knowing that the state had even less evidence here. So to rule for the state here, this court would have to overrule both Pell and Garrett, and it would have to say that it doesn't matter that Mr. Fuller's counsel relied upon that settled case. I'd like to reserve the remainder of my time for rebuttal unless there are questions.
Before you do that, you're not arguing to this court that an unpublished Court of Appeals opinion is settled case law argument?
Pell is been settled case law for 10
I'm
years.
not talking about Pell, I'm talking about the unpublished.
Well, the unpublished nature of it actually indicates that it was settled because all it did was follow Pell.
So you are arguing that an unpublished Court of Appeals opinion somehow settles the law?
Not on its own, no. All it did was apply the settled law from Pell, which was at that point 8 years old and is now 10 years old. So I think that's the only two cases we have on this issue.
Thank you, Counsel.
Mhm.
I believe you're going to reserve the rest of your time, and at this point, we'll hear from the appellate.
Thank you, Mr. Chief Justice, and may it please the court. Ryan Park from the North Carolina Department of Justice for the state. The defendant in this case planned and executed a sophisticated crime to install a hidden device with an automated motion sensor to secretly record his close friend in various states of undress inside of her own home, where she and her husband had invited defendant to live with them and their teenage son. Defendant engaged in this crime over many months, producing and saving numerous sexually graphic images and videos of his friend while she was disrobed in her bedroom and bathroom. For two primary reasons, this crime justified registration. First, defendant showed his willingness to perpetrate a profound abuse of trust. It lasted for an extended period, over which he engaged in at least hundreds of distinct intentional acts in furtherance of his crimes. Second, defendant showed his willingness and his ability to engage in a highly sophisticated crime that required extensive planning, stealthy and skillful execution, and substantial technological prowess. And because of its sophistication, defendant would likely have been able to escape detection indefinitely had he not made the mistake of viewing the videos while the victim's husband was also in the home. In both of these ways, defendant's crime was far more serious than an ordinary peeping offense, which, as in Garrett, typically involves an impulsive act using a cell phone in a public bathroom, and is often associated, as the defendant noted, with mental illness or substance abuse problems, none of which are at issue here. In these circumstances, a trial judge could reasonably conclude that defendant posed an ongoing danger to the community that justified registration. Now, as this court has just discussed, this is the first case in which this court has been presented with interpreting the statutory language. And in that context, there are a couple of interests the state has as the court embarks on that endeavor. And I think luckily for the court, many of these issues are not in dispute. One is that offense conduct is relevant, that all relevant evidence should be considered, and offense conduct is quite relevant to determining whether a defendant is a danger to the community. And second is that the relevant threshold for how dangerous one has to be placed on the registry is far lower than that associated with satellite-based monitoring. And I think that this court's Grady decision, which, yes, rejected the arguments from the state that these two standards were equivalent, is instructive. I mean, satellite-based monitoring is the highest level of supervision and control over a defendant other than incarceration. And registration is far short of that. It is a passive restraint that merely makes already public information more public and easily accessible. And I think one other issue that I think hasn't been sussed out in the briefing sufficiently, but would be helpful for the court's consideration here, is that no matter how this court rules, the defendant here and every defendant who is convicted of peeping in North Carolina from now on has to register under federal law. So the month after the Court of Appeals decision here, the Fourth Circuit issued an opinion that construed South Carolina's peeping statute, felony peeping statute, which is indistinguishable from North Carolina's. This is United States versus Helton. It's cited in our footnote 3 of our brief, that under federal law, people who are convicted under these kinds of statutes have an independent obligation to register with their state, with the state in which they reside. And the defendant here has moved to Louisiana, and so that satisfies the interstate commerce element.
All right, Mr. Park, I saw that argument in your brief, and I'm trying to decide what to make of it exactly. Are you I mean, it seems to me that whatever the standard is under state law would be determined on the basis of state law. Whatever the standard would be under federal law would be determined under SORNA. I assume you're not arguing that it doesn't really matter what we do because he's got to register under SORNA anyway. What exactly is the effect of the fact that such an offense might be covered under federal law for our purposes?
It has no direct effect. I agree with Your Honor. SORNA is explicitly non-preemptive. How it enforces its obligations on states to pass compliant registry laws is through the spending clause. So if the state becomes non-compliant with SORNA, then we risk losing certain federal funds. But the state law, as it applies, is what controls. But the only issue, the reason I raised,
at least as I understand it, and again, correct me if I'm operating on the basis of a misapprehension, under federal law, apparently based on the Fourth Circuit decision that you alluded to a minute ago, a conviction for the offense that we've got under consideration here automatically requires registration without any further inquiry. Under state law, on the other hand, inquiry is necessary.
That's correct, Your Honor.
So that really the issue before us is what is the nature of the inquiry that's required under state law, and what showing is sufficient to necessitate it or to permit a determination of whether somebody's likely to commit an offense in the future. Is that wrong or right?
No, that's completely right, Your Honor. The state agrees completely with that analysis. I only raise it to address the practical point that my colleague on the other side made in terms of the practical consequences here. There is widespread case law that there is actually no practical effect here, because what SORNA requires when someone is subject to registration is you have to register with the state. And there's no federal registry. And so we're just talking about the legal question in this case.
If I may follow up on what you just agreed is the fundamental question that we have to answer. You argued the two primary reasons why this crime justifies registration requirement, but the statute is very explicit that the sentencing court shall consider whether the person is a danger. So this is an inquiry about this particular offender, correct?
Yes, Your Honor.
And the state has the burden of bringing forward the evidence to show that the person is a danger to the community, right?
Yes, it has a burden to show up by preponderance. It's a civil regulatory issue. And
so then looking at, in this particular case, what is the impact of the fact that the trial court said, after he had entered his judgment and said he was going to require registration, and the defendant said, well, could we at least have a risk assessment? And the court said, that actually won't change my opinion. Does that show that this court was not carrying out the requirement of the statute, which requires him to consider whether the person is a danger to the community?
So I don't think so, Justice Earls, and here's why. The Static 99, I think there's frankly a misunderstanding or misapprehension of what the Static 99 is. The Static 99 is a purely backwards-looking retrospective assessment. It's kind of an actuarial analysis. It's conducted, in here it's by, state officials at the Department of Public Safety and elsewhere that looks at a number of objective factors such as the defendant's age, and mostly about half of the factors are their criminal history, and many of the other factors involve the offense conduct, the charged offense conduct, or the circumstances of prior sex offenses, including the charged offense. And so nearly all of that information was before the trial court here. I think the only of the 10 factors that are analyzed in Static 99, the only factor that is not evident from the record is whether the defendant had been married or not. And there's some evidence that shows if you've been married, you're at a lower risk of recidivism. But in every other respect, all of that information was already available to the trial court. And what I gather from his colloquy is that he's very familiar with how the Static 99 process works and how it is scored. And so he accepted that under that process, the defendant here would have been rated as low risk. Although, frankly, and I know this is not, very deep, very very much information in the record, and we're happy to supplement the record if the court wants more information on Static 99. But I'd make a couple of points on that. One is that peeping offenses are explicitly rated as high risk. If you are convicted of a peeping offense, it is scored the same as if you had committed violent aggravated assault, based on research that shows that people who commit peeping offenses are likely to commit other sex crimes, including physical sex crimes.
Is the discussion that you just gave us the way that such peeping offenses are addressed in the Static 99 analysis?
That's correct, Your Honor.
I just want to make sure I'm following you.
Yes, Your Honor. That's correct. That this is all based on the extensive reading I've done on the Static 99 over the past week. And I think one other factor is that 3 of the 10 factors relate to the identity of the victim, again, the victim of the charged offense or other offenses that the defendant has engaged in. And from my understanding, the highest risk is someone who perpetrates a sex offense against someone who is unrelated, but not a family member. And that's the situation we have here. Again, the Static 99 was not conducted. We don't think it was an abuse of discretion for the trial court to have declined the post-ruling request for a Static 99. All of this is simply to say that to the extent that there's a misapprehension that the Static 99 is a psychological evaluation that evaluates the risk of the person based on their present circumstances or their family support or their substance abuse. That's not what it is. It's a criminal justice measure that's pretty similar to the kind of analysis that trial courts and DAs and trial defense counsel conduct all the time. And most of the discussion at the sentencing hearing or the hearing over registration overlapped with what a Static 99 analysis would have been.
Counsel, how do you interpret the plea arrangement term, quote, sex offender registration shall be determined by the court, unquote? And would this be, in the state's view, a matter that suggests that the defendant was conceding that the trial court had the discretion to make this determination? And if that is not the case, and that is not the law, then what would be the state's response to what this court should do?
So we have not relied on that argument that was made in the concurrence below by Judge Tyson. I think the language itself, I'd agree, is ambiguous as to whether the intent of the parties below was to vest the trial court with discretion over this issue. And part of the reason we have not sought a discretionary review on that issue is because our position is that it doesn't matter. And this actually dovetails into one of the larger issues about what the standard of review should be here. I think everyone agrees that this is a mixed question of law and fact. The only dispute is whether someone being a danger to the community is a legal conclusion or a factual finding. The state thinks that it's highly dubious to say that whether an individual is likely to commit sex offenses in the future is a conclusion of law, or at least a pure conclusion of law that deserves no deference to a trial court's ruling. I think as the discussion that we've had indicates, this is a highly fact-sensitive determination that requires analyzing these objective considerations that are at issue in the Static 99, psychological profile, the nature of the offense, the way that the offense was committed. These are all incredibly fact-sensitive determinations, and we strongly believe that a trial court should give at least some level of deference, that it's not a pure question of law.
So just as the defendant is satisfied, I'm sorry, Justice Ervin.
You go right ahead. You were in process and I was interrupted. Go ahead.
You're kind. Thank you. So just as a brief follow-up for clarification of the state's position, the state is agreeing with the defense that the Pell analysis is just fine for the state in terms of how this court should apply, even though that's a Court of Appeals case. State is fine with that analysis that's employed and is not looking to a discretionary aspect of the trial court's determination here at all.
That's largely correct, Your Honor. The only amendment I would make is that our position is that it doesn't actually affect the analysis, because the question of whether someone is a danger to the community, it's really a predictive calculation. Is this person likely to reoffend? That's a discretionary determination itself, and so the standard of review doesn't affect the analysis.
So to follow up on the discussion that you just had with Justice Morgan, and also one that I had with your colleague a few minutes ago, I think that he agreed in response to some questions I asked that his view of what our task here was to, first of all, determine if the trial court specific findings were supported by the evidence, and if so many of them has had sufficient evidentiary support. Did they result in the conclusion that the statutory standard was met? I didn't say that very well, but I hope the point got across. Do you I think he essentially agreed that that's what ought to happen on appeal. Do you disagree? Do you take a different position?
Yes, I think that the way that our positions differ are really, where do you draw the line between fact and law? I think on one side of the equation, it's clear that the threshold, what constitutes a danger to the community, that's a pure question of law that the state would appreciate guidance from this court on. And the specific facts about what happened, how long did the behavior occur, how did it occur, those are pure questions of fact. And if there's this middle area where you're applying the law to the facts, and my understanding of these kinds of mixed questions under this court's longstanding jurisprudence is that you analyze the facts to determine whether they support the legal determinations of whether he's a danger to the community, and that there is a level of deference that's built in on that determination.
Now, you are not, as I understood your responses to Justice Morgan, suggesting somehow that litigants can change the standard of appellate review or the standard by which the trial court has to make determinations based on the language plea agreement. Is that a correct understanding of your position?
That's correct. Although the one amendment again I would make is that.
Well, I can always leave it where you've got to correct me on one thing, so I wouldn't be doing my job if I didn't do that.
Certainly, Your Honor. I think the parties can affect the standard of review to the extent that there's waiver. So if the defense counsel and the prosecutor reach an agreement that the defendant has waived his right to contest a certain determination on appeal or for a certain standard of review, then that waiver is effective. I think this plea agreement is a little squirrely as to whether it can reasonably be construed as waiver, and so that's where the dispute lies.
And you have not yourself, for purposes of deciding this case, construed it as involved in such a way?
That's correct, Your Honor. We have not made that argument.
All right, well, thank you.
Can I ask, to be clear, your view of Pell? Because essentially, are you arguing that the analysis that the Court of Appeals relied on there, that we need to disavow that and not search for evidence that has predictive value in terms of what the defendant's likelihood of recidivism? And if not, how do you square the facts of Pell with this case?
Thank you, Your Honor. So we are not arguing for a square reversal of the Pell standard. We think that the general standard, the abstract standard of what is required to show is appropriate. But we do dispute the way the Court of Appeals in that case applied the analysis. And so at least my understanding, one way to read the opinion, and a lot of this case has been litigated around, kind of dancing around this issue. But the entire static 99 analysis, for example, is entirely predicated on the assumption that the best predictor of future behavior is past behavior. That's actually a quote from the static 99 manual. And so the fact that to the extent that there's a discouragement in Pell towards analyzing the conduct in question, the charged offense, the details of the charged offense, we do think that is wrong. But as the case is presented to the court today, I think we all agree that you can. It's just a matter of whether the circumstances here require registration or not, or allow for registration or not.
Is the state contending that either Jarrett or Pell was wrongly decided?
So we would probably have different views on both those cases. I think we would probably say that we disagree with the ultimate outcome in Pell, and the reason is because in that case there was an extensive record of very long-term repeated peeping offenses against multiple people, and I think that when you have that kind of history of similar, a similar pattern of sexual offenses, that you can reasonably extrapolate from that someone is a risk of engaging in that behavior in the future.
But if that's right, if Pell did not properly interpret what the General Assembly intended when it said that some offenses automatically require registration, but other offenses require the court to make an assessment of the future dangerousness, if Pell got it wrong in how you assess that, and it's been outstanding for 10 years, the General Assembly could correct it, right?
That's correct. The General Assembly could correct it. I think that it's just one case, and the number of peeping offenses where this issue has arisen on appeal is so small that I don't know if there would be a movement to do that. But I think one last point I would make on Pell that relates to this case is that the fact that there's some dispute over this, right, between the parties, but the fact that there is a identifiable mental health issue or an identifiable substance abuse problem, and how courts should analyze that and use it to make registration decisions. I think our position here is that it's actually more troubling that there's no identifiable source of this criminal behavior. The only thing we have is his statement that he did it because he had romantic feelings for the victim. If there is an identifiable problem, then there's a way to address it without using registration. So mental health counseling and treatment, but here there's no source, there's no known source of the behavior, and so there's nothing that a trial court can rely on to say, well, we don't think that this is going to happen again, other than the defendant has learned his or her lesson. And so if there is a substance abuse problem that is resolved, that's in remission, and in Pell they said it was in remission, I think based on that, there could be a reasonable conclusion that that opinion was correctly decided because the source had been resolved.
Well, counsel, I hear you on one hand embracing Pell in terms of the analysis. On the other hand, I hear you not embracing Pell in terms of the outcome. It's sometimes hard to put a position in a silo, and I understand that, but as close as I can get to it, are you suggesting that we look at this on a case-by-case basis, totality of the circumstances basis, weighing of some factors basis, or perhaps something else? Those are the kinds of ways that we tend to operate in some circumstances on this level. Does any of that come close, or are you looking for something else potentially as a standard?
No, I think that's correct. I think that it is a totality of the circumstances analysis based on all the facts and circumstances. And that's why we think that a trial court should have some discretion to weigh all these various facts. I think it would be a Herculean task to try to write an opinion that settled for all time how this analysis should go, other than you looked at every relevant piece of evidence and let the trial court apply their judgment. And in terms of our dispute with Pell, the main focus, and just try to be clear on this, is that offense conduct is relevant to dangerousness. And to the extent that Pell held that it is not, that's our main objection to the Pell analysis.
So, Mr. Park, your issue with Pell then is a statutory interpretation issue.
I think that's accurate to the extent that the court held that what is dangerous does not have any bearing on how the offense that was charged. Again, I want to be clear. I think we have litigated this case over multiple years on kind of dancing around whether the parties actually disagree on this point. But as the case is presented to you today, everyone agrees that offense conduct is relevant, and so I don't think there's a major dispute here.
Right. But if we look back at 14202, and as I asked your friend on the other side, what the definition of is, what do you contend that definition would be?
So we think that Judge Dillon got it right below when he said that it means that you pose a reasonable likelihood of committing another sex offense. And so that, as Your Honor mentioned, of course, means right now you currently pose that danger, and going into the future, you pose that danger.
Right, and for the relevant past as well.
That's correct. That's correct.
So if is means essentially you currently constitute a danger to the community, is predictive behavior relevant?
I think that it's relevant to the extent that that there's I think in most cases the same circumstances will be relevant to your present dangerousness and your future dangerousness, and so it's not necessarily there's not necessarily any daylight there.
Right, but is it incumbent upon a court to make a predictive decision on recidivism when the evidence really is current and past behavior?
Oh, I see, Your Honor. Yes. No, I don't necessarily think so. I think that, the question is tomorrow, the next day, the day after that, is there a risk that a reasonable likelihood this person will engage in a sex offense again? And that's an ongoing analysis, but obviously it's impossible to predict the future. And all we know is what is currently the current behavior, the current circumstances, and the past behavior.
And if that is an ongoing determination and it's predictive, does the fact that you have the ability to petition to get off of the sex offender registry come into play at any point?
Yes, Your Honor. We think so. As was mentioned below, now in about 8.5 years, the defendant here can petition to get off the registry, and I think that the time limit is consistent with what we know about recidivism. So again, back to the static 99, the very first factor that you consider in that analysis is their age, because there's a lot of evidence that as someone ages and as the time between sex offenses grows longer, the risk of reoffense goes down. And so, yes, in now about 8.5 years, the defendant here can petition for removal if he has a clean record, and the trial court, indicated that it may not be the same trial court, but I think it would be reasonable to assume that he could get off the registry.
Thank you, Mr. Park.
But to follow up on your interesting discussion with Judge Berger, you are not suggesting that that the trial court is required to make a decision in the moment and only in the moment as to whether the person in question poses a risk of further offenses?
I think it is all relevant. So I think, the risk analysis is for, the day after the decision, or, the hour after the decision going into the future.
But you're not talking about a decision that's then and there and only then and there.
That's correct. That's correct. So yes,
would it, given that you can't get off the registry for 10 years, even if you're able to successfully petition at that point, is that a kind of time frame that ought to be looked at?
Yes, Your Honor. So, I think the legislative judgment is that any reoffense is one too many. And so the question is there a reasonable likelihood that at any point in the future, this, during the time of that someone is on the registry, up to 30 years, and in some cases up to a lifetime, is there any risk, any reasonable likelihood that this person will commit another sex offense? And so you have to look at the entire span, including the next day and including in 29 years. So I guess the final point I'd like to make, I see my time is running down, is that there is a real risk here to defendants as well, I think, with the reversal. As the court knows, this defendant was facing 72 months of jail time, and he received none through a plea agreement. And a part of the reason why the state is able to feel comfortable entering into lenient agreements of this kind is because there is a belief that allowing for registration and other non-incarceration measures can mitigate the risk of a future sex offense. And I think the state would be less willing to allow for that risk mitigation to occur outside of incarceration if it believes it doesn't have a reasonable likelihood of having someone register. And the final point I'd make is, one of the other, well, I won't make the point. Thank you, Your Honor, and we respectfully request that the court affirm.
Thank you, counsel. Rebuttal.
Brief rebuttal, if I can unmute myself. Okay. Jonathan?
You're unmuted. Go ahead.
Am I unmuted now?
Mm-hmm.
Okay, thank you. So let me start with the state's argument that in 8.5 years, my client can petition to get off the registry. Earlier, the counsel for the state had argued about federal law. If the federal law means anything, it might mean that this is a tier 1 offense and that he might have to stay on for 15 years and wouldn't be able to petition to get off until that point. Again, just shows how intrusive this would be when it's weighed against the lack of evidence of any risk of recidivism. The trial court's statement that Justice Earls talked about, people all the time the registry.
Counsel, you have muted yourself, I believe, or someone has.
Hold the space bar down. Can you hear me now?
Mm-hmm.
Okay, I'm just going to keep the space bar held because the computer is acting with a mind of its own. So that trial court statement that they're low risk people and we put them on the registry all the time. That's showing that the trial court is basing this decision not on the facts of this offense, not on this offender, but upon anecdote. And that's not the type of legal ruling that the standard calls for. The state also said that there should be a level of deference, some discretion in this analysis, and I don't agree with that. I mean, this is the same analysis that you would apply to the denial of a motion to suppress. Mixed question of fact and law. You've got to have findings of fact. They've got to support the legal conclusion, and the legal conclusion has to be correct. Either the findings support the legal conclusion or they don't. There is no deference or discretion built in there, except when there's no challenge to the findings of fact, perhaps. But I don't think that's exactly what he was saying.
So let me pose it to you then, as I did pose it to opposing counsel. If it's not totality of the circumstances, would it be a case-by-case basis? Do you want a bright line rule on this? Or do you think some other standard should apply that's not articulated, that doesn't fit?
No, I think that taking the mixed question of fact and law analysis from other contexts and applying it here is the proper analysis. Then the question is, though, what kind of findings would support the type of conclusion we need or you need to decide here? Whether the person poses a risk of committing sex offenses in the future. And that's where our real disagreement comes, because there has to be some evidence or authority creating a nexus or connection to the future. If you don't have that, all you have is speculation, and then you get these types of arbitrary decisions. Pell versus this case, it's just arbitrary. So you do need that type of finding in this particular analysis.
So you argue for the Pell analysis to be purely applied here?
Yes, and one other point about Pell is that I don't read Pell the way my colleague does. I do not think that it held that offense conduct cannot or does not show a risk of recidivism. It merely held that the offense conduct in that case, right, and this is actually what they argued in their brief, the offense conduct in that case just was not predictive, right? It just offered very little in the way of predicting the future. You know, say you had offense conduct where you've got a statement by the defendant that I'm going to do it again, or I can't stop myself from peeping. But, you know, you could have any type of evidence like that where, okay, there you've got some offense conduct that is predictive, looking towards the future, forward-looking evidence. That's what Judge Brooke was talking about. But the bottom line is that the state cannot just say that the facts of a case indicate the defendant will likely commit sex offenses in the future. The state has to prove it, and the state failed to prove it here. So this court should reverse the decision of the majority for the reasons stated in the dissent, or write its own decision reversing the majority. If there are no other questions, that's all I have. Thank you.
Thank you, Madam Clerk.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina is in recess. God save the state and this honorable court.